Federal High Court in Abuja has nullified Section 839 of the Companies and Allied Matters Act, Cama 2020, which makes it possible for the Commission to suspend the trustees of an association and appoint an interim manager or managers to manage the affairs of the association. The court also nullified Section 842 on power to direct transfer of credit in dormant bank accounts. The judge, James Omotosho, who struck out the sections up to Section 848 of Cama, he says it was inconsistent with the provisions of the Nigerian Constitution. The court earlier ruled that the plaintiff, Emmanuel Ekpeyong, had a local standi to institute the suit on the subject matter. Ekpeyong, an Abuja-based lawyer, had in a suit sued the National Assembly, the Corporate Affairs Commission, as well as the Attorney General of the Federation as first to third defendants. The lawyer prayed the court to determine whether the controversial provisions of sections of the Companies and Allied Matters Act infringed on the plaintiff's right to thought, conscience and religion as enshrined in Section 38 of the 1999 Constitution as amended.
Now joining us to look at this issue is Chibuzor Okereke, who is the convener of the National Political Equity Movement. And from our off-site studio, we have Ogbonna Ukuku, who is a public affairs analyst. Thank you, gentlemen, for joining us.
Thank you. Good evening.
Good. Now, let's look at Section 839 first. The Commission may by order suspend the trustees of an association and then appoint an interim manager or managers, all right, to manage the affairs of an association where it reasonably believes that, well, now lists the conditions. Now, tell us, where does this infringe on the provisions of the Constitution? Let's start with you. Let's start from our studio, our live studio here.
Okay, thank you. You know, since the repeal of the Cama 1990 to now what we have as Cama 2020, it has been a subject of public debate and controversy. A lot of people have raised issues concerning these particular sections. In fact, from 839 to 851, issues of fundamental, human rights. As you know, the Constitution clearly provides that Nigerian citizens have right to peaceful assembly for thought and conscience, and to associate, with each other without any, hindrances. So, if you look at in jurisprudence, the acid test of any proposed legislation is whether it meets constitutional compliance. If you want to propose a bill, the first thing you check is, does this bill comply with the relevant provision of the Constitution? Because the Constitution is the ground norm. Every other law takes, precedent from the provisions of the Constitution. So an attempt to arrogate powers to regulate, determine the leadership and management of association, is also an infringement on the guarantee the Constitution has on peaceful assembly and right to association that people, have. And that you could also see that there have been a judgment of the court restraining the CAC from suspending trustees of CAN and whatever. So that is the main issue. That particular provision actually infringes on what the Constitution had provided. If you will give an agency of government such omnibus powers, subject to even the minister, if you read further in the provisions, you will discover that every action they are to take will have to be approved by the minister, who is a political head. Such laws are not
So that means, Chibuzor, you actually agree with this ruling that says it's actually, it can constitute as an infringement on the fundamental rights of Nigerians. So let me bring in Ogbonna into this conversation. Well, if you look at the counsel to the Corporate Affairs Commission, speaking about Barrister Olowolafe, he actually described the suit as an abuse of judicial process. So I ask you directly, do you agree with this ruling that says, you know what, those sections from 839 to 859 are sort of a breach of the rights of Nigerians, or do you completely disagree and go with the CAC and other respondents to this matter?
No, I can't support the Corporate Affairs Commission on this issue because whether we like it or not, if the Constitution has been interpreted by the judge says that you are infringing on human rights, of course that's what it is. So of course there are opportunities to go to appeal court and then up to the Supreme Court. But nevertheless, I would actually like to take this whole conversation from different perspective. One is the fact that, when we make laws, the legislators, what they do when it comes to lawmaking, that means the right people were not involved in making this law. Because if it passed through first reading, second reading, there was public hearing, and then people didn't pick out some of these holes, and then it passed through third reading, and it was passed, by the National Assembly, and then the legal team of the president did not notice that this will be, will be an issue. It calls to, it gives me, room to. I'm concerned because so that means people are not paying attention to certain things that they need to pay attention to. That's number one. Then number two, we need to also know that the Corporate Affairs Commission will not have such powers given to them, especially when it comes to religious organizations, the trustees of, let's say, a church. If a church is, if the Corporate Affairs Commission will now have the right to appoint people who are trustees in the church, it gives me room to, I'm also concerned because spiritual matters cannot be legislated by, you can't legislate spiritual matters. So these are things you don't understand the motives or the call on this issue. So you don't have such rights. And then trying to give us, an organ of government that kind of power, it's actually very scary. So for me, we need to actually, be able to look at issues properly before we begin to, allow those kind of things, come out to the public, to the public. So for me, I stand with the judge who has given such a, judgment, and I believe that as we proceed to the appeal court and also to the Supreme Court, that nobody would agree with the Corporate Affairs Commission on this issue.
Interesting. Now, Chibuzor, while he was speaking, he made an allusion to church matters, and Amaka was concerned, whispering that, okay, it's about the business side of the church, and I quite agree to that. What do you say to that? Because at the end of the day, we cannot say that that is infringing on or telling on the right of a church, of a spiritual body, or telling a spiritual body what to do. Where do we draw the line in that case, in the case he just raised, between spiritual matters of a religious organization like that, whether it be it a church or a mosque or whichever, and the business side of that religious organization?
Okay, let me say that the concept of business side of church, I think, is new to me. I'll probably research more on it. But I need to say this. This particular act was an executive bill. And most executive bills, as we see in Nigeria, do not go through public hearing. They simply go to committee of the whole most time. And people should really read this law. You see, these sections of the act that the judge had given ruling on is so critical, because if you go further in 842, 843 and the rest, the act actually arrogates powers to the commission to determine the duration of what a dormant account should be, and that they have direction to transfer the other banks to report dormant account of associations to them without recourse to Bofia Act, which is bank and other financial institutions Act. So there are a lot of infringement around that. Also, the issue of business side of a church is something probably I know that there is a lot of laws in Nigeria that are already dealing with all aspects of trustee business, whether it's NGO, whether it's churches, and what have you. Because you see, the spiritual fulfillment of people is even critical to the peace and order of the country. And we have laws that if you misappropriate fund or you are into fraudulent activities, we have the EFCC, we have the CPC that will take on you even without the CAC. So an attempt to create entirely new government with executive, legislative, and judicial powers in CAC is what these sections attempted to do, and it's important that the judiciary has been able to intervene.
Well, the judiciary intervened, and it is not the first time, because if we cast our minds back to March of 2021, where Justice Iang Ekwo had actually restrained, the CAC from suspending or even appointing trustees for CAN. But let's not forget, gentlemen, Ogbonna, let me bring the conversation to you right now. When President Muhammadu Buhari had signed that into law back in 2020, it was hailed, as one of the most significant business legislations of over 3 decades, because at the end of the day, it was supposed to help with the ease of doing business in Nigeria. So talk to us about, the idea behind this law and where the issues are and what we should be doing as we move forward, especially to ensure that the ease of doing business in Nigeria keeps progressing, which the government would say since the signing of the Cama Act, it's been better.
There are better issues to discuss when it comes to doing business. Their corporate businesses, not associations and NGOs. That shouldn't be our focus when it comes to doing business, the ease of doing business in Nigeria. So for me, the focus on this is a bit mischievous, but that's not to say that the Cama Act did not also address some of the very interesting issues that a lot of investors have always had concerns with, like being able to file for for your registration of a company without a lawyer, being able to have your meetings on virtual meetings, and then the board will approve things virtually. There are some good issues. I mean, there were some good, if you look at the law properly, you could see some good things that happened. But I mean, for me, this particular area, we need to also be able to, we have to be very careful with the sensitivity of, of people who exist in this particular, in a nation. So when it comes to ease of doing business, I don't think, it has a lot to do, it has so much to do with the associations, the NGOs, and then the churches. But this also brings me to, one of the most important issues we should look at here. I believe so much that this whole thing came because there's something that the central bank did, which was, being able to say, okay, because of our regulation, the powers to regulate, directors of banks, the CEOs of banks, we have to change them after a particular period of time. Now that can happen because Central Bank of Nigeria, they have that, that power to do that when it comes to banks because they regulate banks. Now, but for associations and NGOs, you can't give the power to, to the Corporate Affairs Commission. Rather, what you should do, because I think this thing's coming from, like in the UK, the Charities Act in the UK. The Charities Act in the UK, makes it, every charity organization like churches, you must come, bring your books to be audited. But there's something we need to look at here. Not by, yes, that can be an independent auditor who will look at the books of the church, but that also, it has to also come within the confines of the church. Let's say an association like CAN should be given such powers to look at the books of the church, not an agency in government. So, these are very sensitive things we need to look at and then, be careful when we deal with such issues.
Thank you, Ogbonna. Have to come back to you on this. I have to take you up on the ease of doing business because that's the primary purpose of the Cama in the first place. So, as amended. So, the purpose primarily is to deepen the ease of doing business. So, I may disagree with you that there are more important issues to discuss. So how do we ensure that all of this imbroglio, all of this does not affect the impact of Cama in the first place, which is deepening the ease of doing business?
You really never said that the other aspects of Cama will be, it pointed out the areas where we should not, you know, the areas where the concerns were. And then the gentleman, the lawyer that went to court, was very precise on his prayers, on the things he wanted the court to look at. So my point is, yes, ease of doing business, there are a lot of issues that investors have, because if you see things from an investor's prism, you know, how to get licenses, how to you know, how they can move goods from one point to another, infrastructure, you know, registration of companies. Yes, you know, countries like Rwanda, you can stay in the comfort of your home and do a due diligence on any company. You can register a company under 48 hours. So those are the kind of things we should be looking at. Those are the things companies are interested. How easy for an investor to repatriate their funds out of Nigeria when they make profit? You know, there's some other issues which I know that the index, you know, the ease of doing business index, will be looking at, not the associations. I mean, what is the role of an association when it comes to doing business? I mean, what's the role of an association? So that's my question. So if you want to take me up on it, I mean, but it's very clear. So let's look at it. So if an association, okay, what role does an association play when an investor wants to invest in power in Nigeria? So give me, I mean, let's look at it from that point of view.
Okay, quite interesting. Well, Chibuzor, let me come to you in the studio right now. During the course of the week, we did see Ifeanyi Ararume. Of course, he was appointed as the chairman of the NNPC Limited before his removal. And of course, he was replaced by Senator Marjorie. And of course, you know, the judgment that he got in favor of himself, you know, against the government, with even a 5 billion, you know, compensation slapped on that judgment. Some would say that judgment was made possible in part for the fact that, you know, the NNPC Limited is now governed by, of course, the PIA and the Companies and Allied Matters Act, Cama, which we're having a conversation about right now. But at the end of the day, part of that judgment by Justice Omotosho did talk about the fact that these sections that we're looking at, section 839 to 859, is inconsistent with the Constitution of Nigeria. So I want to take you up on that. Do you agree with this particular part of the judgment?
Absolutely.
Okay, so expatiate that for us.
Section 851 of the Cama will shock you, that try to establish what they call administrative committee to discipline people and association and what have you. The composition of the administrative committee itself is a usurpation of the powers conferred on the Federal High Court in section 251. Plus, the members of the association are internal unit of CAC and a representative from Ministry of Trade and Investment. And that is why we are concerned, because if you look at the NGOs, trustees, churches are dealing with, you know, trusteeship, not trading organizations. So we are supposed to have representatives from all sectors to be able to be in that committee and be able to give fair hearing. Section 6, Section 36 of the Constitution provides clearly that there should be fair hearing, you know, on any matter, on every individual without discrimination. So this is why these specific sections taken to court by the lawyer is so critical. And you could see that a judgment has come from on the issue of Cama trustees, and we have a judgment that you just mentioned now. So these inconsistencies are what we need to address, and it calls on citizens to pay attention to our lawmaking process. Because if we don't participate actively and ensure that bills are scrutinized before they become acts, you know, assented to by the president, you will keep having this issue, because lawmaking is a political business. Interests are vested. You may want to reform the Cama to bring about ease of doing business, but other people attempted NGO regulation bill and it failed. Social media and it failed. So they went to, because every association is recorded or registered under Part C of Cama. So they found a new way of going to certain provisions of Cama to now give what I may call omnibus legislation that gives unfettered powers and some kind of ambiguity, latitude of power. In fact, Cama can make, you know, certain regulations that can even transform a man to a woman based on this particular provision. No, you can read it. It's so expansive. The leverage is unfettered. That is the challenge. And law should not be made that way, because somebody that is good today may be in charge of CAC. Tomorrow, do you know who is going to come in there? So law should not be made with such kind of tunnel visioning. Yeah.
Interesting. Now let's wrap this up with this for Ogbonna. The functions of the governing board, as provided in Section 4 of Cama 2020, include reviewing and providing general policy guidelines for performing the functions of the CAC, and of course, advising the minister charged with responsibility for trade on the reports. So what should we be looking at in their relationship with the minister in charge of trade?
Yes, we have, like I said earlier, we have very important issues to look at when it comes to trade. You know, the cost of not, participating in the global trade is enormous. Now, the trade deficit we are faced with is something we need to become a bit more productive. We need to look at our, our infrastructure. We need to, design a robust, national plan on productivity. We need to, have, well thought out, financial engineering plan, so that we'll be able to support SMEs to, so that our raw material supply strategy will be, top grade. So for the ministry and whoever is going to head the ministry and the agencies round about the ministry, we need to have very sound people, because I mean, with the African Free Trade Agreement that have just been signed, Nigeria is definitely going to become a dumping ground if we're not careful and then design robust, plans, like I said, strategic plans on how to become productive using our population and our youth population to help diversify the economy. If we don't do that, we are definitely going to become a dumping ground. And then, like I always say all the time, we might have a population, but we might not have the disposable income to be able to or the purchasing power to deal with some of the things that will be dumped on us recently if we don't work on it.
Absolutely, a good place for us to actually wrap up this conversation, at least for now, because we know that this is not the end of it. Let's not forget the National Assembly, CAC, as well as the Attorney General of the Federation. They've indicated that they will be appealing this. Of course, we'll wait for the appeal and even the Supreme Court judgment before we know where we stand with the controversial 839 to 851. Speaking about the Cama Act. Well, gentlemen, thank you for joining us tonight on the program.